Here today to talk to you. I am going to talk about some of the recent Supreme Court decisions that we've had in the United States about patenting or patent-eligible subject matter. I do know that some of the other technical sessions have covered this, so I hope that I'm delving into the cases perhaps in a way that's insightful to you. For those in the room who aren't familiar with patent eligibility issues in the United States, I'm just going to give 2 or 3 slides of background. Just bear with me if this is something you're intimately familiar with. First of all, we're going to be, I might use the term 101, which is a section of our patent statute, the United States patent statute, that defines what is eligible for patent protection. The eligibility issues really are different from the patent application requirements. You know, you can't get a patent unless your invention is new and non-obvious and has adequate disclosure and has utility and all that kind of stuff. Eligibility is whether or not you're entitled to get a patent in the first place based on the nature of your invention. If you think, for example, in the drug context, we know we can get a patent on a new drug. That's a statutory class of invention, a composition. We know we can get a patent on a method of using a drug to treat disease. That's a process, which is part of this patent statute. Process for manufacturing a drug, equipment to make the drug. That's what our statute refers to as a manufacturer. So just to show you exactly what the language of the statute, or excuse me, so the reason I'm talking to you about these issues is that we do live in an increasingly information-based economy. And so patent eligibility is coming up more and more frequently as our the nature of our inventions have to do with the flow of information. So issues like, is the information itself, the stuff that's stored in a database, for example, eligible for patent protection? What about the software that manipulates the information? What about methods of doing business? I'm sure you've heard a bit about that. And then, for example, inventions that relate to the creation of obligations and rights as between industry participants. And a good example of our information-based economy, which I think kind of pulls this all together, is the Amazon.com one-click patent, where basically you fill out your profile once, you can buy future products from Amazon with one click. That is a method of doing business that was patent eligible. And that's, as you can see, very information-based type invention. So these, again, are what the section of our patent statute define as patent eligible: machines, compositions, articles of manufacture, and processes. Separate and apart from what the statute says is eligible for patent protection, we've had these principles develop over the years to define what is not eligible for patent protection. You can't get a patent on an abstract idea. That's a mathematical algorithm is often simply referred to as a mathematical algorithm is often referred to as simply an abstract idea. You can't get a patent on a natural phenomenon, something that's created by nature, or even a law of nature. So those are classic exclusions that the United States has always had. The problem is these types of exclusions are coming up more and more, given the nature of our inventions. So in the good old days, there was a case called Diamond versus Chakrabarty, which said anything under the sun that is made by man is patentable. Well, the Supreme Court in the United States has revisited this. Within the last 4 years, we've had 3 Section 101 cases, and we have another one that is recently been accepted for consideration by the Supreme Court. The Supreme Court in the United States has discretionary jurisdiction. After you go to a trial level, all patent appeals go to the United States Court of Appeals for the Federal Circuit. And from the Federal Circuit, that's the court of last review for all practical purposes, unless you can convince the Supreme Court to take the case. And it used to be that United States practitioners would get pretty excited when the Supreme Court would take a patent case, but they're doing it more and more frequently. So now we're starting to get nervous when they take it, because they always pull the rug out from underneath us. We always know what the rules are, and they change the rules of the game, and you'll see that here in a minute. So these are the decisions that we've had in the last 4 years. First of all, there was the Bilski case. I actually had the honor to work on that case on behalf of Bilski before the U.S. Supreme Court, and that did have to do with the eligibility of business method patents for patent protection. The next case is Prometheus, which relates to diagnostic methods. Now, the title of our section here is Information Communication Technology. So it may be that you don't think the Prometheus case is something that might be of all that interest to you, but because it is a method, it is going to have takeaways for you that you want to be aware of. We also had the Myriad case. This one is more for completeness sake. This really doesn't have to do with information communication at all. But so you'll have the complete picture of the 101 case law. And then finally, the newest case that the Supreme Court has taken up, CLS Bank case. It will be a case to watch. You will need to know about it. It is going to address computer readable medium, which is the language, the phraseology that we've all been using for many years to get software inventions through the Patent Office. And that's going to be revisited, but we'll get to that. So first of all, what was the Bilski case? It's getting old now. It was 2010 that this case was decided by the Supreme Court. The invention in the case was a method of hedging commodity costs, basically setting one price against another price, comparing the prices, and determining which price you're going to pay for a commodity, like rice or oil, based on weather conditions and things like that. The holding in the case is that, and this was challenged, the Patent Office actually issued the patent, but then it went up to the Federal Circuit and it was challenged as to whether or not it should have issued. And excuse me, I misspoke. It was, the Patent Office said you cannot get a patent, and so we kept going up and up and up and up for the Supreme Court to decide whether the invention was eligible for patent protection. And the invention, the Supreme Court held that while generally business method patents are eligible for patent protection, Bilski's invention wasn't. It was described in too abstract of a manner. So business methods are eligible, but you need to claim your invention in a concrete, tangible way to have it pass muster under Section 101. The next case is Mayo versus Prometheus. Now this was a diagnostic method having to do with personalized medicine. Each of us metabolizes drugs differently. If I take an aspirin, I will metabolize it to a certain extent and with a certain speed, and if you take aspirin, your body will metabolize it differently. Well, what the inventors in the Mayo versus Prometheus case discovered was the certain range of metabolite, that's of a given drug. It was a drug to treat Crohn's disease, but they discovered the range of metabolite, that's what a drug turns into in your body, that would most effectively treat Crohn's disease. So their invention was administer the drug, take a blood sample, and if the blood sample was of the metabolite was below a certain threshold, that indicated a need to give more drug, and if the blood sample was above a certain threshold, that would indicate a need to decrease the level of drug. Well, this is a classic invention type format, especially in the personalized medicine and arena, and there's a lot of money to be made in it. There's a lot of investment being made in personalized medicine. So this is another example where it really affects our economy, and we need the patent system to support investment in research. Well, the Supreme Court held that that particular invention claim was not enough to separate it from the correlation itself. Ironically, ironic to me anyway, the Supreme Court started from the premise that the correlation, the range that gave rise to optimum treatment for Crohn's disease was a natural phenomenon. I challenge that. I think that that's an interpretable issue. You know, one drug company might come up with a different range, a different drug company would come up with a different range. It's inventive to come up with the range that is optimal for whatever you're optimizing on. So anyway, the court did start from the premise that that was a natural phenomenon, and then looked in the claim to see if there was anything additional that moved it away from just claiming the natural phenomenon. Oh, I don't have the claim here, but basically the claim was administer a drug, take a blood sample, a low amount indicates a range to, indicates a need to increase, a high amount indicates the need to decrease. So it was, the court said that basically there was nothing in the claim that was inventive or creative enough beyond the correlation itself to make it entitled to patent protection. Now, that is a problem. Our patent bar was very troubled by this because, in a sense, the Supreme Court has kind of messed with the 101 as being separate and apart from the 102, 103 novelty, non-obviousness, because in assessing eligibility for patent protection, the court was looking for something novel or unobvious, some step that was beyond the correlation itself. So that has wreaked some havoc and has practitioners struggling to try to figure out what's the right balance, what inventive or creative steps do you need to add to an otherwise natural phenomenon to pass muster under Section 101. So the next case, and this one is here just for completeness, in the United States, it's always been the case that you can get a patent on an isolated gene sequence. A long time ago, the Supreme Court and Federal Circuit decided that you couldn't get a gene sequence by itself because that falls under that exception for anything occurring in nature. But so long as you put the word isolated in front of your claim, you could get protection for that. It was eligible for patent protection. Well, lo and behold, the Supreme Court pulled the rug out from underneath us in the ACLU versus Myriad case and said that isolated doesn't do the trick. You have to look to the sequence itself that is claimed and figure out if what is claimed is different or not different from nature. So some of the claims in the Myriad case were held eligible for patent protection, and some of the claims in the case were held ineligible for patent protection. They all had the word isolated in front of them, but what made the difference was whether the precise sequence of nucleotides was something that you could find in the human body or not. So now, as I mentioned, we have trial courts, and then we have the Federal Circuit that hears all the patent appeals, and then only discretionary review by the Supreme Court. In the wake of these Supreme Court decisions on Section 101, the Federal Circuit has been barraged with Section 101 arguments saying, by defendants in litigation, saying that that patent should have never issued under the Supreme Court's new standards. That invention is ineligible for patent protection. So the Federal Circuit has decided one case after the next on that very issue, and I have on the slide here many of the Federal Circuit decisions that have said different types of methods are ineligible for patent protection. And if we can walk through them, but if you're like me, it's really kind of a sea change in what is eligible for patenting. I mean, these are the types of inventions that, at least since I was growing up in the patent community in the 80s, we could always consider getting patent protection for these types of inventions. So a method of marketing a product using a shared marketing force, that's a business method, but it wasn't claimed with enough concrete steps. Method of verifying validity of a credit card transaction over the internet. Computer-aided method for managing a credit application, method of administering life insurance policies, and the like. Now, watch this. Look how many have been eligible. This isn't an exhaustive list, but it's a lot harder to find cases where if the accused infringer has given a rigorous challenge to 101 for the Federal Circuit to affirm that the patent is eligible for protection because of the new framework that the Supreme Court has given us. The couple that I'm aware of that have actually withstood 101 challenges are a method of half-toning grayscale images utilizing a pixel-by-pixel comparison of the image against a blue noise mask. You can kind of see there's a little bit more concreteness, a little bit more tangibleness to it. Now, the Supreme Court in the Bilski case did say there's no such thing as a machine or transformation test, but it still is a good clue that something is eligible for patent protection in the United States. And you can see even how this is described superficially, that it does have some a little bit of tangibleness to it. And then finally, a method of calculating an absolute position of a GPS receiver. That's, an important part of this invention. Now, the case that I think you should most definitely be aware of is this CLS Bank case versus Alice Corp. The decision, I haven't counted the pages, but there were like 5 different decisions by different judges of the Federal Circuit, some agreeing with different judges on one issue but not the other issue. And the court considered the computer-readable medium claims and held that they were not eligible subject matter. Now, all the judges had a different analysis, so it's kind of unclear in the wake of the Federal Circuit decision alone what the moving forward position is going to be on computer-readable medium claims. And then, similarly, the court was equally divided on the system claims, saying that they were not that they're not directed to eligible subject matter. So the lower court had said the system claims were not eligible, and the Federal Circuit agreed because they couldn't agree. Basically, if there's an equal division on the court, the lower court decision stands, and so that's what we had here. So there are four patents in the case, and they relate to computerized trading platform for conducting financial transactions. In the invention, a trusted third party settles obligations between a first and second party to eliminate settlement risk. And there's 3 different types of claims: methods of exchanging obligations between the parties, computer-readable medium claims for the code, and a data processing system. I think that's it, yes. So basically, as you can see, for those of you involved in IT and software type inventions and business method type inventions, this case really is going to have, in a sense, broader applicability than any of the 3 cases that have come before from our Supreme Court. So I would encourage you to watch the press about this one. Thank you.